the Chief Justice for giving me the opportunity to write for the bench. First delineated the scope of the reference from the reference. In the scope of the reference is therefore limited to A, whether K. Manjushree lays down the correct law, and B, whether the rules of the game, qua method, and manner of making selection can be changed or altered after commencement of the recruitment process. We discussed the above issues. The scope of the reference is therefore limited
following
to A,
segments.
whether K. Manjushree lays down the
One,
correct law,
when the
and B,
recruitment
whether
process
the rules of the
commences
game,
and comes
qua
to an
method,
end,
and
the
manner
basis of the
making
doctrine
selection
that
can
rules
be
of the game
changed
must
or
not be
altered
changed
after
during the course of the
commencement
game or after the
recruitment
game is
process.
played, then whether the decision in
discussed
K.
the above
Manjushree is at
issues
variance with earlier precedents
in
on the subject,
following
whether the
segments.
above doctrine applies with equal strictness
One,
to a method
when the
or procedure
recruitment
for
process
selection
commences and
as
comes
it
to an
does
end, qua
the
eligibility
basis of the
criteria,
doctrine that rules of the
where the
game must
procedure
not
for
be
selection
changed during the
stipulated
course of
by
the game
the
or
rules
after the game
framed
is played,
either under the proviso
then
to
whether
Article
the decision
309
in K.
of the
Manjushree is
Constitution
at
or a
variance
statute
with
could be
earlier
given a go
precedents
by,
on the subject,
and
whether the above doctrine
appointment
applies with equal
could be
strictness
denied by
to a
change
method
in the
or
eligibility
procedure
criteria
criteria after the game is played.
as it does qua eligibility
As far as the
criteria.
basis of the doctrine is
Where the
concerned,
procedure
we
for
rely
selection stipulated by
on
Act
our
or rules
earlier
framed
judgment
either
in
under the
Sivanand
proviso to
CT.
Article 309
So
of the
far as
Constitution or a statute
the
could be given a go by,
correctness of Manjushree is concerned,
and whether
we examined the
appointment could be
facts of
denied
that
by
case as
change
also
in the
the
eligibility
eligibility criteria after
of
the game is
Subhash
played.
Chandra Marwa.
As far as the
And
basis
we-
of the doctrine is concerned, we relied on
And-
our earlier judgment in Sivanand CT. So far as the correctness of Manjushree is
On the
concerned,
other hand, in K.
we
Manjushree, the
examined the
eligibility
facts of that
criteria
case
for
as also
placement
the
in the
case
select list
was challenged
of Subhash
after
Chandra
interviews
Marwa.
were held which had a material
And
bearing
we
on the select list. Thus, Subhash Chandra Marwa dealt with the right to be appointed from the select list, whereas K. Manjushree dealt with the right. On the other hand, in K. Manjushree, the eligibility criteria for placement in the select list was challenged after interviews were held which had a material bearing on the select list. Thus, Subhash Chandra Marwa dealt with the right to be appointed from the select list, whereas K. Manjushree dealt with the right to be placed in the select list. Thus,
further,
the two cases, therefore, what is clear from the
deal with
above
altogether
is that the
different
object
issues
of any
for the
process of
following
selection
reasons
for
in our
entry
view.
into public
K.
service
Manjushree could
is
not
to
have been
ensure that a
doubted for
person
having
more
failed to
suitable for the
consider
post is
K.
selected.
Subhash Chandra Marwa.
What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise its method. Thus,
Further,
to select a candidate
what is
most
clear
suitable
from
for
the
the
above
post
is
is
that
that
the
the
object
object of any the process of overarching selection principles for entry enshrined in into public Articles service 14 and 16 of is the to ensure that Constitution, a person as more also suitable the for the rules post is slash selected. statute governing What is service and suitable for one reservation post may not be does for in the our other. view the Thus, a appointing degree of authority discretion is slash necessary to be recruiting left to the authority employer slash to devise competent its authority. method. In absence, to select a candidate most suitable for the post, albeit subject to the overarching principles enshrined in Articles 14 and 16 of the Constitution, as also the rules slash statute governing service and reservation. Thus, in our view, the appointing authority slash recruiting authority slash competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also set benchmarks for different stages of the recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extant rules or the advertisement inviting applications empower the competent authority to set benchmarks at different stages of the recruitment process, then such benchmarks may be set any time before that stage is reached, so that neither the candidate nor the evaluator slash examiner slash interviewer is taken by surprise. The decision in K. Manjushree does not proscribe setting of benchmarks for various stages of the recruitment process, but mandates that it should not be set after the stage is over. In other words, after the game has already been played. This view is in consonance with the rule against arbitrariness enshrined in Article 14 of the Constitution and meets the legitimate expectation of the candidates, as also the requirement of transparency in recruitment to public services, and thereby obviates malpractices in preparation of select list. Then we examined whether it applies with equal strictness to steps for selection, and we cited few instances such as shortlisting and other evaluation instances. And then we considered whether the rule can be given a go by. And in this, we relied upon the judgment in Sivanandan CT, as also which was followed by a 3-judge bench in Salam Samarjit Singh. And finally, we considered whether appointment may be denied even after placement in the select list, where we relied on Shankarasan Das. So the final conclusions are as follows. The recruitment process commences from the issuance of the advertisement calling for applications and ends with filling up of vacancies. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extent rules so permit or the advertisement which is not contrary to the extent rules so permit. If such change is permissible under the extent rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. The decision in K. Manjushree lays down good law and is not in conflict with the decision in Subhash Chandra Marwa. Subhash Chandra Marwa deals with the right to be appointed from the select list, whereas K. Manjushree deals with the right to be placed in the select list. The two cases therefore deal with altogether different issues. Recruiting bodies subject to the extent rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. Extent rules having statutory force are binding on the recruiting body, both in terms of procedure and eligibility. However, where the rules are non-existent or silent, administrative instructions may fill in the gaps. Placement in the select list gives no indefeasible right to appointment. The state or its instrumentality for bona fide reasons may choose not to fill up the vacancies. However, if vacancies exist, the state or its instrumentality cannot arbitrarily deny appointment to a person within the zone of consideration in the select list. Let the appeals be placed before the appropriate bench for decision in terms of the answers rendered above, after obtaining administrative directions from Honorable Chief Justice.
So just looking at the
Thank you very much for all your assistance.